could happen under a small window of suitable water temperatures. It's hard to set a daily average or a daily maximum temperature target for these streams. I think given more research and investigation on these tributaries, eventually getting that kind of precision on temperature criteria could occur, but I think right now I would be reluctant to go there.
Yeah, but again, this is where it just makes me nervous. It's supposed to be hot this summer, so it gets hot, and I'm talking high temperatures. Is that really waste and unreasonable use for a grower to be using water when temperatures are, 75, 80? It's this whole issue of balancing.
So you're saying if it's so hot the fish have no chance,
Mm-hmm.
then you wouldn't want. Yeah, and I think you all are talking about making that judgment, not in a gratuitous amount of water. That was part of my question earlier today, is sort of the on-off switch, both for you and for our staff.
I mean, there's a lot wrapped up in saying when hydrologic conditions aren't correct, and you have to start getting into all the details then of what temperature, and as you said, just to get up to the next riffle, and there's a lot of specificity that is, I would say, impossible to add because there would be too many wide-ranging conditions that we can't know all of those.
And you've also excluded the summer.
Yes.
You're only talking about
So just through June.
June and then
And
October again it
Yep.
starts, right?
Yeah, so it's
Unless
so
I'm
this is
misremembering.
self-limiting in many ways.
Yeah.
But to try to say exactly it exactly ends June 15th or it exactly ends with temperature thresholds, we'll be making an error.
Okay. There was a question board member Diadamo asked of Fisheries Agency. I'm interested in building on this a little. What is the time scale of reaction, in the field, in terms of how many folks you have in the field to work closely with growers to make a determination, that the fish have left? Can the volunteer, through the volunteer agreements, are you able to provide timely response, and to enable pretty quick decision making and not, and you'll have a presence in the field to be responsive?
Yeah, so NOAA doesn't have any staff in the field, so I'm going to have to speak a little bit for DFW, but it's my understanding that they do have the staff in the field and they are paying close attention. I don't know the frequency of their monitoring, but I do think the responsiveness is there based on the staff application.
So they would be able to communicate with the groups quickly and say, we've reached that point where we don't have to meet minimum flows, have at it type thing, in a timely way, because the hours will count in the coming month.
Yeah, reluctant to overuse the term real-time monitoring, but I think that there really is a real-time monitoring and evaluation going on with DFW field staff.
Yeah, I don't have the benefit of having looked at the agreements, but presumably some of that's in these agreements, no?
Correct, yes.
And additionally, we have on Mill and Deer Creek already established USGS and DWR gauges that have flow and temperature live on the internet. So we can monitor some of the flow and temperature impacts both upstream and downstream of these diversions to kind of, get an idea when really staff should be, to help coordinate with DFW as far as when staff should be going out in the field and really seeing, are there still fish present? Do we still need these flows? We're on a temperature trend that is going to continue to increase, and we're starting to reach some of these thresholds that perhaps we need to encourage these fish to move on or just call it at this point if they're not present anymore. So that would be, how we would do more of a real-time monitoring of the situation, and then along with that, with the video monitoring on the fish ladders, we'll be able to see a direct response if we do send that pulse flow down to see if fish were moving up and to kind of get an idea whether or not they were still in the system if we did miss some. And then that would kind of direct the next action.
Do you want to address the issue of, obviously the emergency regs were being developed and proposed, and there are some agreements. I still, not having 100% still makes me a little bit nervous on a given water course. And you did give this in the opening yesterday, but will you restate why you feel we still need the emergency regulation and on the areas where there is an agreement.
In the areas where there is an agreement, it would be the time lag in between and it, as Board Member Diadamo said, it does depend on where we want to stand on this, as far as if we were to have something ready to go, there is a time lag before we could get the emergency regulation in place through OAL to make a real-time difference in these tributaries. And likely by the time that would occur, we would have lost the chance to make that difference. So
But where
that's
there is an agreement, I mean, I think what Board Member Diadamo is saying, if, say on Antelope, you have everybody already in agreement, what's the reason for an emergency reg if you have an agreement and there are endangered species provisions in it that could be a incentive to stay in the agreement?
It would be the additional backstop to keep people engaged in the voluntary agreement and keep them from backing out of it.
And is it my understanding also that even with the agreement in place, it would still have to be submitted and go through the approval process, and the findings would have to be made with respect to injury to other water
Other water
users?
users, we
And
still have to do that.
so there is, just because an agreement is in place, doesn't mean that it will. Okay.
That's correct.
We ran through multiple iterations trying to address a lot of the concerns that were raised yesterday. And one, I think, that would speak to the issue that Dan has raised about, is there a way that we could still provide a backstop without fully implementing the regulation? And we came up with text that we could add to Section 877C, which is the section that outlines the minimum flows in each stream reach. And we suggest, or I don't know if we suggest it, but we came up with the idea of potentially adding text that says this section shall only apply if the executive director determines that any agreements in the applicable watersheds entered into by diverters and the National Marine Fisheries Service and the Department of Fish and Wildlife either do not cover substantially all of the diversions in the watershed, which I think addresses the issue on Mill Creek right now, is the 80-something% of the water, is that enough or not? So that would allow Tom to make that decision. It would also, obviously, while the regulation is before OAL, that number could rise. And then, or that the agreements are no longer in effect. So it could provide, with such language, it could provide a backstop and some time for the agreements to go into effect while something is pending at OAL, but still not have the provisions go mandatorily into effect in a way that I hear that people feel is punitive when they've entered into voluntary agreements. I don't know if that's the line we were hoping to thread. I don't know how, obviously that's a policy question, how you all feel, how successful that would be at that. But we wanted to throw some more language into the mix.
I would prefer
That's
that
helpful.
over holding the package
Yeah. That makes
and not
sense.
submitting it to OAL.
If I could just pipe in, I'm here with DFW, and our regional staff just piped in that they do have, they have staff in the field, and they would be able to communicate quickly and respond to conditions as they change.
Oh, yeah, your name for the record. Sorry.
I'm Shannon Little.
Shannon, oh, thank you. All right. Does the language that we've been talking about deal with one of the other issues that came up, and I can't remember who it was, might have been Tim O'Laughlin talking about the nature of the terrain. It was a volcanic rock reference, and it was I think a request for some assurance that the water actually would make a difference. There's the riffle question, but there are other. Can you respond to that? Is it really tailored to passage issues? You were talking about transportation, but is there an issue of it being impossible to help them, or would you? I know we've talked about this a couple times now, but what, in terms of intent, and then I don't want to call it comfort language, but language that we're not going to throw water if we don't think it'll really make a difference. It's part of that reasonableness calculation.
Right. I know there was some discussion about the utility of delivering 80-degree water to
Right.
fish habitat. I don't think there is 80-degree water being delivered to the fish habitat. I'd have to look closer at the data, but yeah, that's part of some of the language in the agreements that gives some consideration to temperature conditions that aren't favorable for survival.
So the agreements have that sort of it makes sense that it would, because if I were making an agreement, I would want to put that
Yes,
in.
particularly for late June and the first 2 weeks of October, which I think is where that consideration is the most applicable. We do have years of fish data that shows that fish are present through June. And on the October side, we know that their downstream migration is triggered primarily by rain events or freshets that triggers them to leave the upper watershed. So we have language that considers those situations in the agreements.
Mm-hmm. Okay, now I have a question about the economic impact. There were some wildly different numbers given, and my suspicion is that some of the numbers that were thrown around were as if it were 50 CFS the whole way through the season or the whole time, as opposed to this on-off switch. How did you come up with the 1 million or close to 1 million number that I'm remembering from the materials?
Dan gets the
But I
paper-
can't put my finger on.
While Dan gets
I'm
the paper.
trying to do things on this. It is not as satisfying as having lots of paper with Post-its on it.
I have lots of paper. Do you want?
Yeah, sometimes.
Dan did the numbers, and he's going to speak to it. But one major difference is that we're talking about numbers that apply to different things. For emergency regulations, based on the timing and the necessity for acting quickly, what OAL and the government code require is the effect on local agencies. And so what we looked at, and the $1 million applied to tax revenue losses to the county. So that's not impacts to
Okay.
growers. That's looking at apples versus oranges of
Okay.
the impact to local agencies as opposed to the impact of diverters. Certainly, we recognize that in order to have that impact of tax revenue, it has to be, and I think we had assumed 10%, it would have to be in order of a magnitude higher of an impact to growers, but that's the impact. Dan can speak to that.
Yeah, we to come up with the county losses, we evaluated it was a spreadsheet and calculations that we got from the UC Davis economists as part of the Bay Delta reg package also, so that we would match up. And there were some calculations in there and some assumptions about how many people could switch to groundwater and so on. And so basically what we did was we went through that spreadsheet, and I won't be able to walk you through that off the top of my head, and found out what the affected acreage would be to kind of get a base. And we used the full flow values as if 50 CFS would be throughout June. And that
Right.
was just basically we wanted to look at it as the worst case scenario for
Okay.
this for the purposes of submittal to OAL. So we used that value. The other assumptions that we had to make, which I had here, was that in October we used a 90% exceedance flow as far as those impacts to the water right holders. Also, you know, if we get some rain or something comes early, then we're going to show less impacts in October.
Right.
And with the crop losses, because we weren't sure how to, without really having the time to look at what, you know, the different parcels of land that would be affected, what crops they grew, to really figure out what the actual impacts of a reduction of water would be to that land, we just simply assumed that crops were lost without the June water. So that's
Okay.
really where the larger
Oh,
impact
so that
came
would be
from.
much larger.
We couldn't calculate a reduced yield accurately. So those were kind of the big assumptions that were used in the county component and I believe that made up, off the top of my head, I think it's around 2/3 of the losses. The others were a little bit easier to calculate. The main one was to the Deer Creek Irrigation District was the other.
Oh, yeah, get closer.
The other utility was the Deer Creek Irrigation District, and they represented the rest of the impact of around 350, I believe.
Okay.
And that was with the same assumptions that the 50 cubic feet per second would be required throughout all of June and all of
So it's a
October.
worst case scenario
Correct.
number. All right, that's helpful, actually. How about responding to the issue that Board Member Diadamo mentioned about when fish are present, and we'd already talked about presence and what it means, presence or lack thereof. You talked a little bit yesterday about sort of the element of judgment there. Is it one fish? Is it three fish? Yesterday we talked about 3 fish or a big slug of fish, unless I just wrote 3 fish or a big slug of fish in my notes. I'll turn to you first. And if there's an example in one of the agreements in terms of how it's dealt with, that would be helpful.
Well, let's see. In terms of putting a number on there, I'll give you the language that we have from the mill agreement, where we talked about flexibility, even with the 25 CFS. So the mill agreement reads, well, 50 CFS through June 14, and then 25 CFS from June 15th through 30th. And if monitoring and evaluations conducted by CDFW determine that fish are not present in Lower Mill Creek, or water temperatures are not conducive to fish survival during this period, and it is mutually agreed to by NIMS, CDFW, and the participant, base flows may be reduced below 25 CFS. So I think there's strong consideration for fish not being present in the system and exposed to the high water temperatures in late June.
But what does that mean, fish? Fish.
Pardon me? How many?
Yeah.
Yeah,
I know,
I'm not
and
gonna
it's
put my
not even
finger
anything
on
you'd
it.
want to put in writing.
Yeah,
so
I mean,
that's
it's
what's
hard,
difficult.
especially when we're talking about juveniles. They're difficult to, they can
Yeah.
occupy a number of different habitats. It can be difficult to see them.
Yeah,
Put
the
a-
juveniles in particular. I don't know anywhere where it's spelled out. I mean, in anything, emergency or otherwise.
No, I agree.
So
I'm
I don't
just-
think it's possible.
No, I agree. I'm just saying it gets back to the issue of what we should be doing, and that is looking at the specific use, the agricultural use, and comparing it, with the circumstances. And we're not able to do that because this is more of a categorical, it's a reg. So we're
Right,
not
but
able
it's
to.
probably not possible to do in an emergency situation.
Mhm.
So the choice is either to do or not to do.
Yeah.
Not to quote Yoda
Yeah.
or misquote Yoda, but I think that would make it an impossibility to act at all in an emergency. That's what I'm concerned about, that there is, I think, an obligation to act if there is, and there is, but how to do it is tricky.
Yes.
Because you can't do a full-on evaluation that you would do in another situation. That's
Right. I don't think we have the sophistication to be able to apply those kind of monitoring techniques here. And they would require, I think, a lot more planning and thought to be applied on a larger or a longer time scale than an emergency.
right. It's hard.
And one other thing to add to that, Matt Johnson isn't here, but conversations that I had with Matt earlier on this, one of the issues was that some of the fish could be holding in the Sacramento River itself, and they can't get an accurate estimate of presence of fish in the river. So the way that I crafted the language, the intent was that we make the evaluation of the temperature is going up, the flows are receding, we expect there's still fish in the system. Let's send a pulse flow down, the pulse that is in the regulation, which is different from the pulses that are in the agreements. We send the pulse flow down, we look for the response. At that point, that was from the regulation standpoint, that was the effort to get the fish to move upstream. And now maybe we keep it at 50 cubic feet per second for a couple days after, but we're moving down to the juvenile flows. And then from the juvenile flows, we do the same process where we see the juveniles, the temperatures going up because they can handle higher temperatures in the lower reaches. and we do the pulse flow again to push those juveniles out, and then we do a recession down to no flow restrictions at all.
But
The idea was that it would be actually,
Just a couple pulses.
it would be, we have an adult pulse and a juvenile pulse to trigger that last migration component up before we lower the flows and kind of say, okay, the run is over. And the way the regulation was crafted would be less restrictive in the intent of that language than the way the voluntary agreements were crafted, in that, you know, the approval of the deputy director and the instigating of that pulse flow may come at a time when the agreement still would like to do additional pulse flows after. So it's different.
So
when
you're
you
saying
have
the
an
reg
agreement.
is potentially less water than the,
It was crafted to be
agreement?
less water than the agreement.
so it's the bare minimum backstop amount as opposed to a scarier, bigger amount?
Correct. The agreements have a 2-week rolling post flow, I believe, till June 15th, between April and June 15th. The regulation has one of those post flows for adults and one for juveniles. And the juvenile one would be in June.
Another question, I know people who are here for 13 are impatient, but this is a hard one we need to think about. Some people suggested yesterday, I think it was more than one, since these are adjudicated streams, why not go to the court as opposed to doing this? Lawyers, start your engines.
As with so many other things in this water year, I feel like we're kind of a broken record over here, but there just wasn't time.
Mm-hmm.
What you are getting was, as soon as we could get out, what we felt that we could support, what we had the coordination with NIMFs and with CDFW on, what we felt like we could support, what we felt like looking at all of the water rights in the watershed, looking at the potential economic impacts, looking at all the things that we would need to prepare in order to even know what to ask the court to add to any of these agreements. The idea that could be faster than the 15 days, we don't even know what the court calendar is like. If you can get on the schedule, you know, that quickly. So, you know, we felt like 1058 gave us a mandate to use this. This is a very, I mean, for us, this is like lightning speed. And it's the mechanism that's available, whereas even just the research on the other issues would have taken probably longer than the OAL review process, much less getting the filings together, getting a DAG assigned, getting them up to speed, having that be not just a priority for us, but for the Attorney General. It just seemed that even if there were a possibility to go through an adversarial process to establish these things, which takes, you know, much longer, and we would probably have had to have our ducks even more in a row in order to do that. That there just wasn't time.
And let me add one additional factor that we considered in this approach, as opposed to the courts that did the adjudications, and that's that this is a matter that the board is very well versed in. I mean, I don't mean this individual emergency regulation, because you've had it for a very short time, but water rights, waste, and unreasonable use. The court I can't say when it last touched the adjudication, but it determined relative priorities, and we also do that, but this regulation doesn't determine relative priorities, so we're really made every effort to not intrude on the court or step on its toes, but the amount of time it would take to bring a court up to speed, to the speed that you're at on the issues of waste and unreasonable use and how that fits into the water rights priority issue, legally, factually, is substantial.
I'm sorry, I have to respectfully disagree, and this is, I think I'm a minority on this, but I just have to speak my mind here. Running out of time or not, and I do appreciate all that you have done, the whole staff on this, and the drought. This is just one of many things you're having to deal with, so this is not meant to be disrespectful at all. But when it comes to water rights, we've had so many people come in here and say this is a system that's existed for a long time and it creates stability and people will fight it. So when we go out of priority, which is what we're doing on health and safety, and then we're also going out of, in my opinion, we're going out of priority with respect to public trust flows. It rearranges the priority. I think it'd be better to look at creative tools, voluntary agreements, other approaches, adjudication, making that effort, because we're going to have to deal with it anyway. People are going to file suits. I think Mr. Manassian said something about inverse condemnation, and I think Mr. O'Loughlin did as well. You know, for the remaining, you know, it may end up just being dear, so we're going to have to spend the time anyway. And so I think in light of that, I mean, my personal opinion is we've heard a lot about this over the last couple of days. This is quicker, it's, you know, it's easier. And I think that part of the calculation in making that determination should also consider that there's a whole army of people that will get ready to fight water rights. And that'll take up a lot of time.
I don't know that there's any way around that in this drought, and I think there are many. I don't think there's any way around that. People define what they think of as water rights based on their custom. It's not always the way the law actually reads, and we're going to end up having to litigate it out. But if the answer is we can't take emergency action in an extraordinary drought, that makes me uncomfortable too.
No, I'm
so
not.
There's nothing easy. This is like one of the hardest decisions, at least in the time I've been on the board, not just because of the substance of it, but because it comes into people's long-held views, and that becomes very difficult to deal with an emergency, but we're in an emergency, so it's just, I just think this is very difficult.
I agree, it's difficult. I'm just speaking to looking at other approaches that, why not inquire about adjudication? There are, I think, 2 of these streams have adjudication, and as I understand it, courts retain jurisdiction. So I'd like to know more about that process. I think that it would be potentially a creative approach that could work. I don't know the answer to it, but it'd be helpful if we explored other solutions that maybe would take less time.
In this case, you think it might have?
Andy Sawyer, Assistant Chief Counsel. We're talking years, maybe decades, to amend a decree. It hasn't been done yet. The only proceeding I can think of where it's being attempted, it's taken over a decade. We are not a party to these adjudications. So you first have to serve all the parties and become a party. The drought's going to be over before we even deal with the procedural first steps before we get to the merits. So that the reopening adjudication is an option if you're dealing with a long-term in-stream flow issue. But we're not a party, and the court has not yet dealt with in-stream flows. There will just be a long battle about whether we can become a party and whether you can reopen the decree before you get to the merits of what you should have done by the time it's long since passed for this drought.
Okay, that's fair enough.
Interesting. It's not like you can go into writs and receivers in Superior Court on an emergency. So you can't do it at all. Andy? So an emergency procedure isn't available at all? Or
I was
we could
thinking
try and go in, but
issue of
people would
pending
litigate our
adjudication.
standing in there.
I mean, if you initiate a public trust action and then name all the parties, again, the number of parties involved means that the procedures are just not going to be something you can get through in the time, the time provided. An administrative approach, and especially a use of regulations, is much more expeditious. In my opinion, the only thing we can get done before, at least assuming this is the last year of the drought, before the drought is over.
Other questions? All right. At the risk of ping-ponging people more, there are some things that, language and other things that you've talked about. I, for one, would like you to, at least some of you or one of you, to be able to work on that and bring other changes back. Is that what they've been doing right there?
We're prepared, with the exception of we have, based on the comments, so what Les already is talking to Janine about are several changes to the regulation itself that we've heard from the board members that you would like. I believe one of those is, if you're looking at the change sheet, page 5, it's page 1 of the day 2 change sheet. But we heard some concern with the within 5 days suspend curtailments. So one change that we're proposing is the deputy director shall, comma, no later than the next business day, comma, suspend curtailment orders, because I think cognizant of the 1 day, 24 hours, something like that, it might be the situation where something comes in late in the day, and whether we're just concerned that she has enough time, but not too much. So if that meets your needs, that's one proposal, and that would go in 3 locations. So the subparagraph large E in each of the 3 tributary streams. The other change is the language that Mariana read a little while ago that would go into subsection small c at the beginning of section 877. I'm not sure if that's ready to go up on the board yet. She can read it to you again if you'd like. And then I have about 4 paragraphs that are responsive to concerns that we have that we would propose adding to the resolution and not the regulation itself. So from a timing perspective, we would just have to type them up. But
Well, that's why I was hoping you could type them up. You can put it on the board, but it's nice if you can put it at the back of the room so maybe people who are tactile like me want to be able to look at it
Yeah.
a little bit.
I'm just giving you a heads up that we
That
are
sounds
fairly ready to go, other than
good.
just, I mean, if it's faster, I could read them as
No,
opposed to
I
typing.
want to see it. I think we need to see it. Some people can take
Yeah.
things in through their ears. I need to take it in through my eyes. And other people may too.
The changes to the regulation itself are being given to Janine right now, so I can come back with the changes to the resolution in 20 minutes with
No, that's
copies for the
great.
back
And then
of
we
the
can
room.
let some of then we'll come back, look at them, and see where people are. And then we'll go back to item 13 for a little while. Okay. All right. Next up, thank you for your attention. Obviously, I'm trying to read the body language on different issues in the back of the room, but that is imperfect. Next person is Valerie Kincaid.
Chair Marcus, maybe after Ms. Kincaid, I could make a point of clarification on the enhanced enforcement under the emergency legislation.
Sorry. Yeah, I would like
That's
you.
fine.
Go ahead and do that first. Yeah,
Would
do
you
that
like me to
first.
Okay.
But
Well, I think I misspoke. You had asked a question about whether the board would have some of the enhanced enforcement provisions, the advantage of that if it were to elect not to adopt an emergency regulation. And I think I said no. But there were 2 pieces essentially to the emergency legislation. One was a new provision making drought emergency regulations under 1058.5 subject to a $500 per day penalty. They're also enforceable by cease and desist order. That's violations of drought emergency regulations. The other piece in the emergency legislation was just enhanced penalties generally for unauthorized diversions or violations of cease and desist orders during the drought. And that exists whether or not a drought emergency regulation is being enforced. Under the board's existing enforcement authority, those enhanced penalties exist during the drought. Did I make things less clear?
Less clear than when you explained it to me before. Say it again a different way.
Okay.
Start with what the legislation gave us regardless of the format and what the emergency regulation
How
would
about
do.
pulling up the slides, because I think that there's, some of this information is on the slides.
Was it?
Mm-hmm. I think it's, yeah, I'm looking for it here.
So irrespective of drought emergency regulations, the board has authority to issue administrative civil liability complaints for unauthorized diversions,
Right.
and also to issue cease and desist orders in response to various violations.
Right.
And under the drought emergency regulation, there are increased penalties
Right.
for unauthorized diversions, and there are increased penalties for violating a cease and desist order issued during the drought. In addition to that, the emergency legislation made amendments to 1058.5, authorizing the board, expanding the board's authority to adopt drought emergency regulations. A violation of such a regulation under the new legislation can be enforced directly. There's a penalty of $500 per day. In addition, the board can issue a cease and desist order if someone were to violate a drought emergency regulation, and that would be subject to penalty of up to $10,000 per day.
What is immediately enforceable?
Well, as opposed to having to take a second step, under the board's existing authority, curtailment notices aren't enforceable orders. So in that sense, they're not immediately enforceable. If a notice of curtailment were to be sent to a diverter who the board determines is diverting when there isn't water available under their priority of right, if they were to keep diverting, then the next step would be to either issue an ACL complaint or a CDO, cease and desist order, or both, against that diverter, and then you would follow the normal enforcement proceeding. But if someone were violating a drought emergency regulation, the board could issue immediately a complaint for violating the regulation, instead of going through first the notice process and then the enforcement process.
So is it just a speed thing or is it a resources thing? Both?
Both, I think. There is a possibility for an as-applied challenge to the underlying determination in a drought emergency regulation. But putting that aside, an initial case could be brought against somebody just for violating the regulation, as opposed to having to establish the facts supporting a determination that water is unavailable for a particular diverter in each and every individual enforcement case.
I see. Okay.
So it does have the potential for streamlining enforcement.
All right. So it's enforcement and then the exception that you get from the emergency regulation?
And regulations are also subject to a different standard of review.
Different standard of review. Okay. Great. Thank you for clarifying that. Ms. Kincaid, thank you for waiting.
Sure. Valerie Kincaid, San Joaquin Tributaries Authority. The San Joaquin Tributaries Authority has a number of concerns. Many of them have been talked about earlier. So I'm going to touch on 4 today, and hopefully they won't be too repetitive of earlier comments. The first is regarding number 3, the reallocation of outflow. And the concern the San Joaquin Tributaries Authority has about that is that there's a process in place. It's phase 2. It's started. And the concept that you would get around that longer due process and fact-finding process in emergency regulation context and set interim flows and basically reallocate outflow as it currently exists in this type of regulatory process is highly concerning, and we think unsupported by legal authority that the State Water Board has. The second is priority, and a lot of people have talked about priority. I'm going to try to be as clear as I can about the priority issues that we think there are. On number 3, we clearly think that that's turning priority on its head. It's fairly clear. It's asking senior water right holders to come in and backfill for juniors. I think everyone gets that. Tam mentioned the public health and safety, and that also is a concern. It is a reordering of priority. And then another priority issue, as I see it, that hasn't been talked about as much is the impact that the TUCP has had on curtailments. And we understand that the temporary urgency change petition was ordered, but it was certainly not ordered without effect. As I read that, it has somewhat tied the hands of the board to proceed with curtailment. You've allowed junior water users relief from fish flows. To ask senior water users then to come in at any time and provide anything that is close to a fish flow, or perhaps even the result of backfilling the abandoned flows after fish flows have been met in the TUCP, it's a little convoluted, but is a violation of priority. So from where we stand, the mere fact that you issued a TUCP and let juniors have relief from fish flows has really limited your curtailment of more senior water users. The third concern that the SJTA has is emergency regulations. And 1058.5, as it's amended, is fairly specific and very narrow regarding curtailment. It allows curtailment for availability based on priority. It does not allow for curtailment based on fish flows and a lot of the other issues that we're talking about here. Those are public trust issues, and as other folks have said, the public trust process is a longer fact-finding, intense weighing and balancing process that we're not doing here. So in my opinion, the way people are reading this the authority under the emergency provisions are pretty broad, and we should all go back and look that it specifically says based on availability and priority. So unless we're making those two findings, I think that the use of emergency regs in this situation, we should dial back quite a bit. And then finally, to Mr. O'Brien's point earlier, goals. And we have a big concern at SJTA regarding whether this is going to meet the stated goals. My general understanding is that the stated goals are to keep water in storage for cold water pool. I think a lot of folks have talked about, and certainly Kevin talked about on the SAC side, and on the Sacramento side, between the dwindling amount of full natural flow that's coming into the system and the fairly large pre-14 rights, you're going to see very little of that water physically dedicated to outflow. The other component for the San Joaquin side is that we have several non-project reservoirs. So to the extent that you want to curtail post-14 right to store water for non-project reservoirs to allow project reservoirs to maintain their storage, the senior non-project reservoirs would have a major concern with that. Again, based in priority, if you curtail our post-14 rights to put water in storage so that the junior project rights are able to keep their water in storage, I think that's a fairly obvious
but
problem.
But isn't stored water senior? It's a different kind of thing, even if it's junior. It's different because it's not.
Well, on the San Joaquin side, we often we have post-1914 rights to divert water to storage. Right. So if those were curtailed, we would not be putting water into our non-project storage for the stated purpose of keeping water in storage. So we would be releasing water so project reservoirs could maintain storage while our reservoirs, who are senior, would be diverting water.
Right.
I mean, releasing water for that purpose.
Right, I get that. But isn't part of the purpose of this, it's not just cold water, it's storage for cold water, but also for salinity control next year? Right? If we end up emptying, I mean, if you end up with the stored water being emptied out way faster than people estimate for the temperature control and all the things we've talked
Right.
about, because of having to meet outflow requirements and depletions that are from junior water rights holders, then don't we have a problem we need to address?
Well, on the San Joaquin side, there are also salinity requirements that you could. So, I mean, I guess from our perspective, we want to make sure when we're talking about storage that people understand. I mean, it sounds fundamental, but from the earlier conversations regarding storage, it seemed like there was an assumption that it was all project storage. And frankly, our system is largely not project storage. So to the extent that our rights to divert water to storage are curtailed, so project storage can be maintained, you know, we're seniors, they're juniors. It's a major problem.
If I might make just
Well,
one
you answered that.
minor
I know there's
comment.
an answer to
And
that.
it's not going to answer the question. It's instead going to say, I saw the staff put up that the goal, I guess, was to conserve project storage. That is not the goal. The goal is to effectively administer the state's water rights system.
Right.
A consequence of effectively administering the state's water rights system is that some parties who otherwise might have to release stored water wouldn't have to release stored water. But that's a consequence of the goal. That is not the goal. I think it's our job, our duty, to effectively administer the state's water rights system, and that's what I think we're trying to do here.
And I would just suggest that to do that, we should follow the rules that we all live and play by today, which are water right priority.
Oh,
And this proposal certainly challenges that.
Some of them.
Yep.
In your mind. Yep.
Can I ask you about option 4?
Sure.
With what you just said? Can you explain why you would be, you didn't even mention, you prefer option 1, I assume?
That's correct.
Okay, so could you talk about option 4 and if that challenges some of the principles that you just outlined?
So option 4 would be the term 91 curtailment in real time, but not to reallocate outflow. Is that right? Well, to the extent that it would still curtail post 1914 water rights to divert water to storage. I mean, the reason for that would have to be, frankly, a senior water use. It can't be for a junior to keep their water in storage.
So can staff respond? I don't know that I understand that, the option 4.
And that's how
Well,
option
anyway.
4 would work, but it would treat the delta as an interconnected basin, so such that there are, diverters, senior diverters in the delta that required water, then that would require an order of priority curtailment, starting with the most junior diverters, working on down until the more senior diverters were able to divert. Option 4 doesn't involve any contribution to delta outflow or any rebalancing of water rights for to conserve stored water of project water. It does involve protecting stored water for which other water right holders don't have a water right for that, or a valid right for that water.
If I can add, I'd like to address the idea that somehow under a term 91 scenario, either under option 3 or 4, the projects would be treated favorably relative to other water right holders. I just don't think that that's the case. It's not as though they would be allowed to be diverting to storage under those periods, because under term 91, by definition, they're actually system-wide, at least, augmenting natural flows with stored water releases. And in fact, they would be still, in a sense, in a worse position than other water right holders, because whereas if they were curtailed under any scenario, other water right holders would be precluded from diverting to storage or directly diverting. They wouldn't be asked to release water from storage. And to the extent necessary to meet modified delta outflow requirements, the projects are on the hook to release water from storage.
Right.
Could you?
If I could also just clarify, the situation that you're describing regarding your diversions to storage would be the same under option 1 and option 4, correct? It's not the application of, it's not the data set.
Right, and I think from
the way
right.
we're describing curtailments in terms of priority, right?
Right.
So it's not a distinguishment. Okay.
That's
Thank
true, and I think, frankly, it goes to the purpose of curtailment. I mean, if the purpose of curtailment is to serve more senior water users, then certainly that's within the realm of priority as I understand it, and as the system has historically worked. If it's to curtail to make up for outflow that the projects can no longer or will no longer meet, that's a different purpose and clearly rises to much more problematic issues. Yeah.
Got it.
Thank you.
Great, thank you very much. Next, John Rubin and Stephanie Morris in tandem. Hey, thanks for your patience, both of you as well.
Good afternoon, Madam Chair, members of the board. My name is John Rubin. I'm General Counsel for the San Luis and Delta Mendota Water Authority. And I have some hopefully brief comments, and they are a bit
and helpful, illuminating comments. I know.
So, and they're a little bit more general than some of the comments that you've received so far. I do want to start reiterating a point that Mr. Howard just made this morning. A lot of discussion about operation of the projects, potential effects of curtailments on storage and exports. And while that has a place in the discussion, I think it's been overemphasized, and I do look at it exactly as Tom stated. And the question before you is curtailments. And the basis for curtailments is to prevent illegal diversions, to ensure that the State Board is administering water rights and ensuring that the priorities that have been set by law over the last 100+ years is being adhered to in this time of shortage.